Okay, I guess we can get cracking to the questions.
Yes, we may as well do that.
It's interesting for me also to pick your brains on useful tips for advocacy, because I think every advocate has their own secret weapons.
Oh yeah, so one thing I like to do before a hearing is, if I know who the judge is going to be and it's an open court hearing, I like to go down to the courtroom and try to observe what the judge's style is like. So I found that in advocacy, an important part of it is knowing who your audience is.
Yeah.
Some judges may be quite interventionist. They ask a lot of questions and you have to be prepared to improvise a lot, whereas some judges prefer to let you develop your own case as you go along, and they're quite silent and don't ask you many questions. So I find it useful to know if the judge I'm appearing before is either one of these, so that I can tailor my style accordingly.
One thing that comes to mind also is that I think when we first start in advocacy, we tend to go with good morning, Your Honour, good afternoon, Your Honour, when actually the proper British way to do it is may it please the court.
Yes.
I think most judges are fine with good morning, but some maybe would prefer you to use the more formal language.
I think it depends on the hearing you have. So I think if it's an open court hearing, yes, you should say may it please the court. But if you're doing a long list on a PTC or some closed chambers hearings, I think it's quite normal to say good morning, Your Honour. Because it's a different setting.
I agree with that. In terms of real tips for advocacy, it's totally different if you're talking about cross-examination on the one hand, or appellate or sort of submission-style advocacy. I think for submissions, the one thing that I've learned over the years is that 1 or 2 points, normally that wins you or loses you your case. I think when I first started, you wanted to make every single point that you thought was good. But ultimately, it does seem that cases turn on those big major points. And if you're not going to persuade the court or the tribunal on that major point, that major document that you will be able to show that the other side of the witness, for example, is not being honest.
Actually, to build on that point about documents, I think one thing I've learned, even despite a short period of time practicing, is that facts do matter a bit more than the law. Because, no matter how many cases you cite or you distinguish, it's not going to help your case very much if, like you said, that one document destroys your case or shows that your own client is not being 100% truthful. And I think a lot of young lawyers, advocates, because they're fresh from law school, there's a tendency to maybe focus a bit too much on what the law says when, a bit more emphasis should be focused on the underlying facts to each application or summons that they're doing. I think particularly when you go up to the Court of Appeal, or even a High Court appeal from the state courts, that's where the law can sometimes turn the case. And that's one of the tips that I thought I could share, is that, the being familiar with the case makes a difference, even in terms of the facts. If you're just reading the head note, that is a problem, because most of the time you won't be questioned into the details of the facts, of the intricacies of the holding. But it's the sense of being able to be trusted by the court. So if a question is asked you about a particular paragraph that you didn't draw the court's attention to, and you're not familiar with that, that doesn't bode well in terms of the confidence the court has in your, the thoroughness of your research. So I found being prepared makes all the difference, even not just on the law, but on the facts. If you know your documents at the back of your hand, even if you say, like, if the judge says, there's this document, I say, I think that's in agreed bundle, volume 12. I don't know if I could just pick it up. Yes.
It somehow, the judge starts to think, this guy knows his case, and I can trust that, he's gone through the material and not misleading the court, giving some sort of a half-baked impression. I thought that segues well into a question I wanted to ask you, because I think you do criminal advocacy.
Yes, I do.
As do I, though I only do it pro bono. But I was going to ask you that, for criminal advocacy, it's very different, because documents-wise, you don't really have that as much.
So I'll deal with it in two parts. What drives me is mainly because I think that every accused person deserves the right to full and vigorous representation. And arising from that is to minimize the impact the court system has on each person. Because for accused persons in particular, being put into the criminal justice system can be quite dehumanizing. You go to court, wait around for your case to be called, and there are many adjournments sometimes which don't seem to make sense. You're at the mercy of the court's directions, and at the same time, you have to pay your own lawyer to defend your case, and there's a lot of stress on them. So I mean, if you think a civil litigant feels stressed out, I mean, imagine what an accused person feels like when he has a jail term or even a lengthy fine hanging over his head.
Sure, yeah.
So I see it as my duty to guide them and do my best for them. I mean, it's been some time while back, but I think you did a high court criminal trial that went all the way up to the Court of Appeal. So how was that like?
Yeah. So I mean, I agree with everything you've said. I mean, I try to do at least 1 or 2 pro bono cases a year, and I always try to take those that are claiming trial because I think for plead guilty cases, I think it's not that it's less important. I think the opportunity should be given to even younger lawyers to do that, and I always encourage my juniors in the firm to take up these cases, and I will guide them. But you can give them the chance. And even on the cases that I claim trial, I mean, usually what I do is I put on 1 or 2 juniors and allow them to cross-examine the more minor witnesses, the police officers, not to in any way minimize the police work, but generally there are many ones where they are just escorting or just doing searching, formal witnesses, or the doctors. So in terms of claiming trial, I find that, I don't know whether it's your experience as well, that maybe 8 out of 10 of the cases you take on, they initially want to claim trial, but by the end of the trial starts, they'll plead guilty. But that's usually because we also do our job in terms of engaging with the prosecution at CCMS, looking at the evidence that they sometimes share with us, and also pushing back. And quite often you be able to reach some sort of a consensus on what is a fair sentence, which may be something very different from what the prosecution taught themselves at the end. And with obviously the blessing of the court through submissions, you can get your client what I think for them may be a fair outcome. So I think that's why quite often they find that you do plead guilty even though you claim trial. So even in those cases, I don't think that our work is not helpful.
No, I think it's important because in a way we are helping save court resources by ensuring that a case that would have gone for a full trial actually is resolved much earlier on.
Exactly. And you brought up that case. I think that's the case of Halifi bin Muhammad. That's probably one of my most memorable cases actually, because it was the first high court trial that I did. So even before I did my first civil trial, I did my first criminal trial pro bono in the high court, and we actually appealed up to the Court of Appeal. So before the high court, I would say it's memorable because it's so different. Even though I had seen many trials before, civil, I was second chair, third chair, or before that, my time as a law clerk, watching from just in front of the judge. It's so different when you're lead counsel, and so different in a criminal case, where I was not as familiar with the criminal procedure, and where you don't have all the documents that you're used to. So what I found, and this is maybe my tip for young advocates, is that you've got to be expansive in your questioning. Because if you just follow the condition statement, and sometimes you don't even get that, you hear for the first time the witness's evidence at trial. But even if you have a condition statement, it's usually short. It's 2 or 3 pages. And you need to really probe every aspect of the incident. When it talks about if it's a rape case, for example, like Halifi, you really need to probe everything, be very detailed about in the incident that happened, but also what happened before, what happened after, because you never know what could be helpful, what could be an inconsistency. I think that was very important for me. And I think the other thing that it trained me to do is to realize that, we are officers of the court at the end of the day. In my case, I think he admitted certainly that he had committed robbery, and that even on his case, he had treated, I think, the victim very unkindly. So in terms of my cross-examination, I think I was mindful to be always respectful. And how do you rigorously test the evidence without crossing the line to make, the victim relive a traumatic memory and make it worse? So I think that was a great learning experience. And though he was convicted at the end of the day, the judge actually reduced the charge from aggravated rape to simple rape, because I managed to persuade the court there was at least a reasonable doubt that the hurt that the prosecution described in the charge did not occur. And we went up to the Court of Appeal. I tried my best, and what I can say is we got a second hearing before the Court of Appeal, which I think showed that there was certainly something worth arguing. But ultimately, I think the court was fair. They considered it carefully. They even had 2 hearings, and I think they dismissed the appeal at the end of the day.
I think they also dismissed the prosecution's appeal, right?
On sentence, exactly. And so I think there was overall a good outcome. But it was a great learning experience for me. And I would encourage every young lawyer to take on pro bono work. And it's quite exciting because each witness is different. And what I like about, the forensic side of advocacy, like cross-examination and things like that, is that, you've got to get a handle of the witness quite early on, like a battle of wits. And if you're doing back-to-back trials, that's really...
You have to get up on a lot.
Yes. It's very training. So it's probably your first chance to be able to be lead counsel. And it teaches you the flexibility because you don't have the documents to contradict someone. It's really, you have to think on your feet. And I think that is infallible.
I wonder if you prefer a more interventionist bench or a more, shall we say, a colder bench?
As in all things in life, I think that balance is important. Both have their benefits, and depending on how your case is, the most important thing about being an advocate, and you touched on that right at the start, that you need to know your audience, and we are here to persuade, be it the court or the tribunal. And we need to be able to fit the style that they are adopting. And I think both styles are conducive to the getting to the truth, because ultimately judges and tribunal members, they do what they do best. If they are interventionist bench, then they're intervening well and probing it well. And if they are slightly colder bench, that's also sometimes they're a very thoughtful judge.
That is true.
Really thinking it, giving everybody an opportunity to say what they want to say, but then really putting all the pieces together. So I personally don't mind either type of judge.
Of course, the CA, we all know, is highly interventionist, but a few High Court judges are also well known for diving in quite vigorously.
Yes.
I've also been before some High Court judges who just let you say your piece and hardly any interruptions. On balance, I think I do prefer a bit more questioning. I think it is a bit unnerving sometimes if you're just talking uninterrupted for a good, half an hour, 45 minutes, because I would like to know if my points are getting across or if the court is interested in any other area. And I'd like to see some indication of, the interest or what the focus is so I can adapt my submissions accordingly.
Yeah. I mean, I agree with that. I mean, I think the main point for me, which I don't know whether that's the same thing for you, is that you want to know what the court is concerned about.
Yes.
And if they don't question you, don't follow up, then you're not sure if you've persuaded them, or maybe they are concerned about a particular point and you just didn't see it.
Yeah.
And so I think that's certainly a thing. Even if they agree with you, you want to know that they are agreeing with you. So it's probably easier to read if the judge is asking questions. I'm going to ask you, I suppose, a question that you might have expected. You're obviously the second winner of the Joseph Grimberg Outstanding Young Advocate Award. So it's more recent for you than for me. But
it's still a number of years back.
How has the winning the award changed your career? How has it changed your practice?
I think for me, the first thing it's done is on a personal level, it's given me some form of external validation for what I do. Criminal law is not something that most people practice full-time or even most of the time.
Yeah.
And it's also not a path that most young lawyers coming out of law school would say, I want to be a criminal lawyer. Most of them would rather be civil lawyers focusing on arbitration, the usual route. So that, to me, felt like a validation of the work that I've done and showed that whichever path you choose, if you put in the effort, you will be recognized for it. So that was one. Two was that it did raise my profile within the firm, and it's given my bosses and my clients more confidence to entrust me with major pieces of work or to have more autonomy in running my cases. So there's all this talk about giving young advocates more opportunities in court to do cross-examinations, to lead appeals. To be fair, I think most law firm partners do try their best, but at the end of the day, they are accountable to their client. So what this award has done for me is it's given my clients the confidence to entrust their work to me. to entrust major pieces of submissions or cross-examinations. And my boss can, with all confidence, tell the client, look, my senior associate is more than capable of doing it, you should trust him. And the client has a basis to say, okay, sure, I'll do that. So I think I took a more major role in a major trial my firm did. So for example, I cross-examined the lead investigating officer who actually led, I think, a combined team of MAS and CAD officers in, I think, a 3-year investigation into this stock market case.
Sure.
And I mean, her evidence basically covered, well, prosecution exhibits in the thousands, data that was disclosed to us in hard drives, but I was entrusted with the task of challenging her evidence, and I like to think I did a pretty good job of it. So yeah, all in all, I think winning this prize has had a significant impact on both my practice and as a matter of professional development.
Yeah.
So now that I suppose we're reaching the end of this very pleasant conversation, so Lionel, as the inaugural winner of the Joseph Grimberg Prize, do you have any tips or helpful points you'd like to tell to potential applicants?
Sure. I'll tell them all the same tips I told you before you won the award. But no, actually I can't remember what I told you. But I think for me, what my sense at least on what the judges who interview us are looking at really is, firstly, I think obviously highlighting your involvement in important cases. Not just that, but what role did you play? So obviously what I did was to highlight the cases where I was lead counsel, where I conducted the cross-examination, I did the appellate advocacy. I think that's probably more important than having done a $500 million arbitration, but you were the fifth chair.
Yes.
So ultimately, I think they want to see you stand up on your feet and be able to be accountable for the submissions. I think that's very important. The second thing is that I think to showcase what is unique to yourself, showcase your passions, what maybe only you or a few other advocates are doing. So I think you show for yourself, obviously, the criminal work, I think, must have played an important part. Because they were, that was a unique sort of experience that maybe not many other advocates were bringing to the table. I think for myself, obviously, I was doing the usual civil litigation. I think maybe my pro bono cases did help. I also was young amicus curiae. I think that may have been helpful. And I suppose the other thing that I'm passionate about, which I did highlight, and I think maybe played a part in my selection, was giving back to the community in terms of teaching for many years. You know, in SMU. Before that, I was also teaching in NUS, my alma mater. But I helped set up the moot program in SMU, so I'm really involved in that moots there. I teach evidence. I wrote a textbook with one of my best friends, who's a professor at SMU. And I think showing that well-roundedness and that you're not just, serving yourself at the end of the day, that you want to transmit these skills that you've learned, that your mentors have taught you to the next generation. That was perhaps something that helped me. But again, I was saying that it really, each person has their own unique experience. I'm not suggesting in any way that all the applicants should start doing criminal work exclusively or going to teach in the university if that's not something you're passionate about. But I think everybody has something that is maybe unique to their own practice, something that they can try to showcase. And I think that's what perhaps the judges were looking for. Someone who's obviously also important is a good representative of the award. I think that's something that I've always held close to my heart, and I think every young advocate should remember that at the end of the day, you are an officer of the court. You must never lose the trust of the court, or an arbitration tribunal for that matter. So while we advocate vigorously, we must never mislead and always give the court the confidence that you are there to assist and that you will not in any way abdicate that duty. I think when you have that integrity in your practice, that is essential. I don't think a person who has anyway lost the trust of the judges will be selected for this award, because that's something that I think is really important. So those are my tips, at least, and I see they helped you, so maybe they will help the next applicants. But
you probably don't remember this, but I do remember one tip you gave me was to choose your references carefully. Pick people who are able to demonstrate all the qualities required by the award. So I think that is something that applicants should consider. Senior practitioners held in high regard who've had the chance to see them in action and can testify to the excellence in advocacy, of course, but also, like you alluded to, their standing in the community, what community work that they have done. I mean, my references, I did pick them for those criteria, and I mean, that clearly did help. Yeah. Do you remember of course you remember who your references, right?
Yeah. I mean, my references were one, my senior partner, Alvin Yeo, senior counsel, who's been a fantastic mentor to me all these years. And I really learned all the tips of the trade from him, just watching him, seeing the way he prepares, seeing the way he advocates in court. And he was very kind to write a reference for me. The other reference was the Dean of SMU, Yi Han, who is someone I've known for many years, and I think he probably spoke to what I've done in terms
he
of...
was a year ahead of you in law school, right?
Yeah, he was a year ahead of me in law school. We were also law clerks together when we were in the Supreme Court. He was 1 year my senior, and we had many a day at the foosball table downstairs. But that's not the reason he wrote me the reference. But honestly, I think, I was really trying to showcase what I've done in terms of giving back to the students. And so he's privy to all of that, and I think he could write to what I've done in terms of helping set up the MOOC program and continuing to my involvement there, teaching, writing, and things like that. And Alvin, obviously, I think very kindly spoke to what I've done in terms of my actual practice work. So I think I was hoping to give a sort of balanced view in the way I pick my references. And
no, I think that does give a full 360 view as it were.
Yeah, very good. It was illuminating and engaging conversation.
It was.
And we'll thank SAL for
SAL.
inviting us. Thank you.
Thank you.